Hello, and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about two fundamentally important rights in Canada. The first is the right to be presumed innocent until proven guilty, and the second is the right not to be denied reasonable bail without just cause. These two rights are interconnected. Now, there's a couple of news stories that have really raised these topics to the forefront. The first is the story of former Liberal candidate Kevin Vuong, who's now going to be sitting as an independent MP. He was kicked out of the Liberal Party as a result of it being disclosed that he'd been charged with sexual assault, notwithstanding the fact that those charges had been withdrawn. The second story is that an individual who was charged with first-degree murder in the death of a Toronto police officer was released on bail. And lots of political figures and lots of people were saying, oh my God, this is such a travesty. So we'll talk a little bit about that as well. First, though, let's have a look at the Charter and what it has to say about this. So from the Charter of Rights and Freedoms. So Section 11D is the right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. And E is the right not to be denied reasonable bail without just cause. And if you're wondering why they'd put in a right not to be denied reasonable bail without just cause, it's because you're presumed innocent. And so it is considered an injustice if you end up sitting in custody for 6 months, 9 months, a year, and are ultimately acquitted. So that's why we have the right not to be denied reasonable bail without just cause. Now, you'll note that there's reasonable bail and just cause. It doesn't say that you automatically always get bail. It says that there has to be some cause for detaining you. And the criminal code actually sets out reasons why you can be detained. The first of those reasons is if you're not likely to show up for court. So they can hold you in custody if you're going to be fleeing the jurisdiction or if you just kind of habitually don't go to your court dates. They can say, listen, we have a way to make sure you go to court, and that's by not letting you out. So that's the first sort of ground. The second is if you're going to, or if there's a substantial risk that you are going to commit further offenses. And further offenses get weighed a little bit in terms of what kind of offense. Because the court is probably going to be more concerned if you're going to commit murders than they are if you're going to commit mischief, which makes sense. The third ground is if it's going to bring the administration of justice into disrepute. And this is a bit of a complicated ground. There's been a lot of court battles and arguments over this one. But essentially what this requires is a very holistic consideration of everything that's involved. So they have to consider the strength of the case. They have to consider the seriousness of the offense. They have to consider the circumstances, what is going on there, and also whether or not you're likely to be looking at some serious jail time. Because, of course, they're less likely to want to hold you if ultimately you're looking at, 30 days or a fine. It kind of doesn't make sense to say, hey, listen, we're not going to sentence you to jail time. You're just going to have to pay a $500 fine. If you've already been in jail for 6 months, you kind of feel like that would be a kick in the pants. So that's why that's a relevant consideration. So let's go to the story of the first-degree murder charge, because this is the one that's got a lot of people up in arms. And I think I'm probably going to annoy some of you when I say, I don't have an issue with this. Some people have asked, how can bail even be a possibility when you're accused of something like first-degree murder, especially first-degree murder of a police officer? Well, the key word is accused. He hasn't been convicted of anything. It's entirely possible he hasn't done it. That's the whole point of the presumption of innocence. He's legally presumed to be innocent. And so the question is, how can we detain a guy who is legally innocent? The court is going to have to grapple with this question, and in fact did grapple with this question, I'm sure, in doing things like assessing the quality of the evidence against him. That would have been one of the considerations on that third ground that I mentioned. So I don't know. It's entirely possible that the Crown's case may have some problems with it. It may be that this is a situation where the Crown's case might be weak. So these are the sorts of things that the court is going to consider. And when they released him, they didn't just say, okay, off you go. Best of luck. See you on the next court date. They in fact released him on some fairly stringent terms, which includes more than $300,000 in cash, apparently, as well as a bunch of conditions that include house arrest and a lot of stuff. He's going to be on electronic monitoring. He's got to forfeit travel documents. He's not allowed to drive a vehicle at all. So it's not just a situation where they just release him and say, that's it, he's going to be under very strict conditions, conditions that are quite similar to what somebody might be sentenced to if they were sentenced to a period of house arrest. So now, I've said that I don't know what was going on at this bail hearing, and that's true. There is a publication ban, and a lot of people have commented on that and said, why don't we get to know this? Why don't we get to have this published? Well, again, the presumption of innocence here is key, and also the right to a fair trial. Let's look at the criminal code section that actually limits the publication. And that is section 517 sub 1 of the criminal code. Order directing matters not to be published for specified period. If the prosecutor or the accused intends to show cause under section 515, so if they're going to be speaking to bail, he or she shall so state to the justice, and the justice may, so the justice can, they have discretion to, and shall, so in the second portion, they have no discretion, the justice must, on application by the accused, before or any time during the course of the proceedings under that section, make an order directing that the evidence taken, the information given, or the representations made, and the reasons, if any, given or to be given by the justice, shall not be published in any document, or broadcast or transmitted in any way before such time as A, if a preliminary inquiry is held, the accused in respect of the proceedings are held is discharged, or if the accused in respect of whom the proceedings are held is tried or ordered to stand trial, the trial is ended. So just to break this down a little bit, if the accused asks for this publication ban, it's automatic and mandatory. The court has no discretion. If anyone else asks for this publication ban, then the justice may impose it. So that's a discretionary thing if it's asked for by the Crown or if the justice themselves thinks that it's called for here. And that publication ban is not forever. It lasts for a limited period, and that period is limited by the trial time. If a prelim is held and the accused is discharged, so they say you're not going to stand trial for this, the charges are dismissed, then the publication ban ends, and at that point, the reasons can be reported on. Or if they're ordered to stand trial, either because they go directly to a trial or because at the preliminary inquiry they're said, okay, you're going on to trial on these, then it's after the trial is concluded. This is to protect the right to a fair trial, because if there is a jury trial, for instance, you don't want the jury contaminated by hearing the representations and so forth made at the bail hearing. For instance, it might affect a fair trial if you have public commentary where the judge says, listen, the reason why I'm releasing this guy is because I think the Crown's case is real bad. Do you think that might affect a future juror if they've heard a judge say, case is real bad, it's got all sorts of stink over it, I don't see how they can possibly get to a conviction here? I think that might affect them. The flip side of that is that if the justice says this is a really good case, that similarly might affect them. There's also a lot more leeway here for the Crown to introduce evidence or theories or various other things that might be inadmissible at a trial. And so you don't want the jury pool contaminated by having heard all of these things that they ultimately might not hear at a trial. So that's part of the reason here. This is a provision to ensure that we have fair trials. And you'll note here that fair trials goes both ways, because one of the concerns is that if the judge says, hey, case is real bad, that it might be unfair in the sense of too generous to the accused. You've got jurors who've already heard that it's a real bad case. What are the odds that they're going to get to a conviction at that point? Maybe not so good. So that is why we have these publication bans in place. Now, a lot of politicians have commented here, and frankly, I think most of their comments are offside. They say, you know, this guy shouldn't get bail. Well, you don't know that. You weren't there. You didn't hear any of the representations. And usually when politicians get upset about a case that's in the news, they're often doing so wrongly. They're often doing so in ways where really they want to see somebody convicted or held, not because the evidence necessarily calls for it, but because they're just real angry at what that person represents, the symbol of that person. So we've seen this before. There's, the Jian Ghomeshi case, notwithstanding the fact that the evidence in that case basically said, listen, we can't rely on these witnesses. They've got all of these problems. Sure enough, lots of politicians had opinions, and in general, those opinions were bad. They're not great opinions. So that's sort of the first aspect. Let's also move on now to talk about Kevin Vuong. And he's still making news. His the MP he's replacing is now saying that people shouldn't work with him. They shouldn't, they want him to step down, and they're actually unwilling to brief him, apparently, on new information, notwithstanding the fact that he's been elected. Now, in part, he was elected because he was kicked off the Liberal ticket too late for his name to be removed, or for the Liberal stamp to be removed from his nomination, from the ballots. So there is some question there as to what the right thing to do is. But it's important to remember as well, legally speaking, he's presumed innocent. Now, one thing that the courts cannot do and do not have the power to do is declare that people have to like you. The courts do not have the power to say, listen, this guy's been acquitted, or, the charges were withdrawn. Therefore, you can't treat him badly. You have to like him. You have to think he's a great guy. Courts don't have that power. And so the degree to which this harms people is going to vary directly with the degree to which your job requires you to be popular. So if you're talking about a politician, that's a lot. Similarly, if you're talking about a guy who talks on YouTube, that's probably a lot. If I expect that if I was charged with something, even if I was acquitted of those charges, I would probably lose a lot of people following, even if the charges were utterly ridiculous. There is a serious danger and harm that comes just from charging people. And that threat always increases the power of the state. It increases the power of the government. Think about it when we think about denial of bail. If all you need to be locked up is for them to accuse you of doing something serious, well, what good is it if the evidence is weak? What good is it if they say, hey, you killed this guy in Ontario, and I'm like, I haven't been to Ontario in years. How could I have committed a murder 6 weeks ago when I haven't left Alberta? But if that's all that they need to lock you up, then the government basically has a power to lock you up at any time just because they feel like it. I don't want to give the government that power, and I think if they had it, it would be abused. The most likely way it would be abused is overcharging. They think that you've done X, but they're going to charge you with something more serious in order to push you into a category where you can't speak to bail, which of course gives them great leverage in negotiations, right? So I think it's essential that there always be the possibility of speaking to bail. Doesn't mean you're going to get it necessarily, but at least you get to have a hearing in front of a judge who gets to make the decision and can evaluate things like, have you been overcharged, or is the evidence against you weak? Those kinds of considerations. I also think it's relevant to think about, as a society, the impact and the effect of reputational damage. Because normally we actually have some protections, defamation law and so forth, that protect you against people trying to harm your reputation. But the government can lay charges, and you don't typically have a remedy if you've been wrongfully charged. Most people who've been wrongfully charged or who are ultimately acquitted don't really have a remedy against the government. But that charge in and of itself can destroy you. Kevin Vuong is probably okay. He's already been elected, so he's going to get to serve out his term, however long that is. He said he's not going to resign, and quite frankly, as much as you might think, hey, he should, he doesn't have to. Legally speaking, he can sit there if he wants. So, he's doing all right. But when you start talking about people who are mechanics or teachers or other people who depend on someone hiring them in order to earn their living, it can be very destructive because the charge itself can get you fired, and the charge itself can prevent you from getting a new job. Often the newspapers might report that somebody was charged, but they rarely report when charges are withdrawn or when somebody's acquitted. So you get reported that you were charged with something, but when you're cleared, even if the court says, listen, we think these charges were utter garbage, they were lies made up specifically to harm you by somebody who hates you, the news probably doesn't cover that. So when a future employer plugs your name into Google because they want to see, hey, what's this prospective employee like, you probably don't get the interview. So I'm also going to just talk a little bit about kind of an extreme example here when we say you don't have a right to sort of people liking you. And this I just happened upon by chance. I went camping during the election, which of course is its own form of stress when the elections just happened and I was out of cell reception. But I happened upon this little historic site, and I'll bring up a picture of it here. It's just this little sort of shrine. And my wife and I, we decided to go and have a look at it and see what it said. And I'll try to bring it up here, but I'll also read it to you. It says, Murder of Constable Greyburn. Constable Harduk Greyburn of the Northwest Mounted Police was shot and killed by unknown persons in the Cypress Hills, November 17th, 1879. He was the first mounted policeman killed by violence since the force was organized in 1873. Starchild, a Blood Indian, was accused of the murder, but was acquitted in 1881. So it's been more than a century, and they still have a monument dragging his name. I think maybe it's time we just declare Starchild cleared of this. I think that seems fair to me. You know, presumption of innocence, so this is presented by the province of Alberta. Hey, province of Alberta, maybe you want to just declare Starchild to be clear to this one. I feel like 100 years, you had your shot at investigating him. If you don't have any further evidence, maybe it's time to just drop the accusation. But yeah, there is no protection for your reputation. Even 100 years later, you might be getting called out in a monument for being acquitted of a crime. Anyway, thank you for watching. I hope you found this to be interesting and possibly educational. I know lots of people may disagree with me on the bail thing, but I will say lots of the time when you hear people talking about bail reform, which always means granting less bail, they talk about firearm offenses. Well, firearm offenses can be anything from you walked into a bank, put 2 rounds into the ceiling and said, everybody to the floor, fill up the bag with money, to people who get charged with fairly serious firearm offenses because they screwed up. They didn't realize that they weren't allowed to do something. They didn't realize that the paperwork had expired, all sorts of things. So keep in mind, you know, anytime you're saying, hey, I want to give the government more power to do bad things to people I don't like, well, you're giving the government a sword, but you don't really necessarily get to choose where they swing it. And I can guarantee you that eventually they will get around to swinging it at people you like or people you're feeling sympathetic to. So I'm always reluctant to just say, hey, government should have unlimited power, or it gets into places I don't want to be. Anyway, thank you for watching. I want to thank all of my viewers, but also my Patreon supporters. There's a link to the Patreon below. At the $50 level, Jonathan Wheeler, Jason Elliott, Canada's National Firearms Association, Mike, Carl Martin, Jean-Guy Toussaint, Ivo Nedev, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc-Olivier Damour. And at the $20 level, Raymond L. McKinnon, Matt Ward, Mark Whittington, Jane Babe and Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., and Andrew Elsich. Thank you as well to the $10 patrons who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge, and see you next time.